credibility of witnesses. 101.20 is weight of the evidence. 104.05 circumstantial evidence. 104.50 photographs and diagrams of illustrative evidence. 104.94 is testimony of expert witnesses. 104.95 is opinion testimony by lay witnesses. 105.20 is impeachment or corroboration by prior statements. I've included 105.60 evidence of defendant's character trait. That was just a placeholder more than anything yesterday. We can talk about that. 104.10 is motive. 104.36 is flight in the first-degree murder case. 101.30 is effective defendant's decision not to testify. Then on the substantive offenses, we have 106.14, which is first-degree murder, giving both on the basis of malice, premeditation, and deliberation, as well as the felony murder rule. There's a lesser included offense of second-degree murder included in that instruction. The first one is for Sylvester Taylor, the alleged victim. The second one is for the alleged victim, Anglia Taylor. And that's identical other than the identification of the victim. Then 206.17A is attempted first-degree murder where a deadly weapon is used. In that case, the alleged victim is LaTanya Holden Allen. And then the next is 208.10 is assault with a deadly weapon with intent to kill and inflicting serious injury. The alleged victim being LaTanya Allen. It's not consistent, but LaTanya Holden Allen. In that instruction, I give a peremptory instruction that a firearm is a deadly weapon. I give that same peremptory in other charges as well. I also give the peremptory instruction that the defendant inflicted serious injury, or, excuse me, that a gunshot wound to the face and chest are serious injuries. I give the lesser included offense of assault with a deadly weapon, inflicting serious injuries, the lesser included offense on that. And then 101.35 of concluding instructions. I've included in the concluding instructions again about the manner in which the defendant is clothed, or that he may have been restrained in an earlier time. I included that language in the concluding instructions as well. So let's start, let me start with the state and ask whether there are any instructions that you wish to have included or discussed, or any other objections, corrections, or suggestions you have with respect to the instructions.
Yes, Your Honor. First of all, I do have one request for a jury instruction, and that's related to basically the continuous transaction doctrine with regards to felony murder. May I approach?
Yes. And
I'll approach with I think the case that, one of the line of cases that's cited is State v. Campbell. And
Do you have a copy for me?
I'm sorry, Mr. Brown, let me give you that. May not have made it down to court with me.
I can pull it up. It's 332 NC 116. So they can have my copy. And
I've got a copy of the case, just not the proposed instruction.
Yeah, that was the instruction I wanted to see. Yeah. But if I could I approach and see a copy of the instruction?
Yes.
And Your Honor, but basically what we're asking for is that you instruct the jury during your, or I guess included in your felony murder instruction, that the continuous transaction doctrine applies to felony murder. Under this doctrine, a person may commit felony murder when the felony occurs before, during, or soon after the victim's death, as long as the felony and the murder form one continuous transaction. And I need to talk about the felony murder rule in just a minute, but I mean, obviously the underlying felony that you're instructing the jury on at this point is LaTanya Holden's injuries, or the attempted first-degree murder of her. And you know, because I think the evidence does show that it was the last crime to be committed there, that I just think it would benefit the jury to have that doctrine stated to them so that they understand that it can be before, during, or after, as long as they find it's one continuous transaction.
All right. What is?
We'd ask them to just add it.
I'm sorry, you would ask?
We'd ask them to just give added instruction.
All right.
To the extent without necessarily saying that we agreeing to
All right.
the instruction of felony murder itself with that.
All right, well, let's move on then and see if there's additional discussion about felony murder instruction, and then we can take that issue up as.
Yes, sir, Your Honor, and that's the other thing I wanted to get to. You know, 14-17 says that the felony murder rule can be invoked when a killing is committed in perpetration or attempted perpetration of any arson, rape, sex offense, robbery, kidnapping, burglary, or other felony committed or attempted with the use of a deadly weapon, and that would satisfy the felony murder rule. Your Honor, what I would ask the court to consider doing in that case, you know, because of this, is instruct the jury under the felony murder rule for each Sylvester and Anglia Taylor that they must find the assault with a deadly weapon inflicting serious injury against LaTanya Holden. You know, it seems based on the statute, and I believe also from some case law, to be sort of a predicate felony under the felony murder rule. You know, you'll probably instruct them that a firearm is a deadly weapon, and that the state only need prove that the defendant committed that assault, intentionally fired the gun at LaTanya Holden, and that assault resulted in serious injuries to her. I think that satisfies the felony murder rule, and I think that properly instructs the jury what our burden is to require them to find, you know, the attempted first-degree murder and all of that sort of specific intent. I think actually moves and shifts the burden against the state as to what the law would actually require. So I'd ask that you consider just taking the language, and you're giving that assault as a lesser included, you know, in your charge anyhow. So just remove the attempted first-degree murder under the felony murder rule and insert the language from the assault.
All right. Brown? Or Ms. Amber?
We may have a moment.
That there should only be one of those two that be submitted for the felony murder.
Isn't that what you're saying?
Yes, Your Honor.
Okay, I'm clarifying. Okay. Well, it would be our position that the one that you originally did would be the better one. I don't wish to be heard any further on it.
All right, I think that it can go either way, and neither assault nor attempted first-degree murder are on the list in 14-17, but the pattern instructions contemplate adding that fifth or fourth element that says when a perpetration of any felony where a firearm is used.
Yes, sir. And it would be my contention that that's sort of a catch-all provision. Wherever a deadly weapon is used to commission of a felony, that it qualifies.
I don't think that it makes a great deal of difference as to which of the two felonies that alleged to have been committed against Tanya Holden are listed as predicate felonies. So if the state prefers to have the assault, I don't see a reason not to do that. I think that the law certainly supports that.
Thank you, Your Honor. We would ask for that.
All right, anything else?
The state doesn't have any other requests, Your Honor. We're otherwise satisfied with the instructions.
Let me just clarify one thing. For the predicate felony, are you suggesting it should be assault with a deadly weapon, inflicting serious injury?
Yes, sir.
All right, so
The lesser included that you're instructing them on.
right.
Right. I mean, obviously, we're still going to argue for the other ones, but I'd like to argue to the jury that all we need proof to you is the Class E because, well, for various reasons.
I don't want the jury to be confused. And so I'm looking at the instruction. And so the first element would be the defendant committed the offense of assault with a deadly weapon, inflicting serious injury. Establish this element. The state must prove to you beyond a reasonable doubt. All right, that the defendant assaulted. All right, I think that works. There's no intent language in that first element. I think that would work.
Yes, sir.
Okay. All right, let me turn to the defense and ask whether there are any objections, corrections, or suggestions.
None in proposed instructions that you have given us.
With respect, and let's go back to the evidence of defendant's character trait. There was, I think I permitted an opinion as to whether he was a good father. I think
there's been, the opinion question, I believe, specifically, some evidence was for nonviolence.
And a good father.
And a good father. Okay, the Sandberg's reminded me was also to be a good father.
I'm not sure that good father is a character trait per se.
For the purposes, I think it is a character trait, but I think for purposes of the issues in this trial, I would probably, yes, that's probably not something that needs to be instructed on.
Certainly not at this phase, Your Honor. I mean,
Right.
Yeah, we obviously, if we get to the next phase, we can revisit, there's completely different issues on that. To him being basically nonviolent before April 9th. There was one who did it in terms of an opinion after an objection. I think several other people testified to it.
There was an opinion about, from Mr. Watkins, that was allowed. That he was not. Trade. Or not being violent. All right. The state wish to be heard with respect to pattern instruction 105.60, evidence of character trait.
No.
All right, so I'll include the trait for for not being violent. All right, and nothing else? No. I'm inclined to include the, I want to read the case law, but I'm inclined to include the continuous transaction instruction. If that's instructive to the jury and consistent with the law. So I would be inclined to include that. Do you have a copy of that?
Of the case, Your Honor?
No,
Or the-
I have the case.
I'm sorry.
You still have it?
Yes, sir. And I put the side of the first case in there. There's a line. I think I handed you Campbell.
All right. I'll incorporate that into the discussion about felony murder, into both of those charges, one for each victim. All right, so the form of the verdict sheet, I have copies of that, both, if you want to just read it, please.
Okay. Latanya, we need Sylvester. form for 14 CRS 002275, count 1. It doesn't identify LaTanya. She's identified in count 2, guilty of attempted murder of LaTanya Holden, but for count 1, the C assault and then the E assault. Just for clarity, if we could put that in.
Yes, please, just put it after series. Yes. And for consistency, I'm happy to call her LaTanya Holden throughout the instructions. That's what the indictment says. I know she goes by a different name.
We put no objection to that.
Yeah, for consistency, I think that's fine, Your Honor. If that's what it says on the indictment, that's what we prefer you do.
All right, I'll confirm that. And I mean, the very first time I mentioned that she also goes, that she goes now by LaTanya Allen, but
Right.
yeah, okay. Just clarify that for the jury. Okay. That'll work. All right. Well, is there anything else that we need to take up?
I think there's only going to be one argument from the state.
There'll be 2 from the defense.
Okay.
All right, so
You wanna read it?
well, the state will have the final argument, and you're waiving an opening.
Yes, Your Honor.
All right, and you wish to break up your closing into 2 parts.
Well, break it up into that.
Ms. Hamburger and I plan to make an argument.
Right, that's fine.
Yeah.
It'll be
Back to back.
back to back.
Yeah,
Before the state.
yeah, I don't think we have an option the other way.
You'll be arguing first.
Right.
But it'll be 2 parts. One of you will be doing.
Yes.
one part, the other will be doing
Yes,
the other
right, right. And we,
Right. You don't think the jury.
Day one, and we may change our mind overnight. I highly doubt it, but we'll probably just do the second one.
Not a problem.
Okay.
Will anybody be using PowerPoint presentations?
We're working on that, Your Honor. We expect to use PowerPoint, and actually, what I'm planning on doing is not to have any photos associated with the PowerPoint, and we'll have a separate folder of photos that we might display at the same time on the small screen that we've been using throughout the trial.
All right, I think that'll be fun. All right, if there's nothing further, then we'll be in recess until 9:30.
Tomorrow morning.
Recess 9:30 tomorrow on God Save States. All cool.